When my husband died, our trusted family lawyer smiled at me across his mahogany desk and handed me a forged will that left my $1 million ranch to his own shell company. He thought I was just a confused, grieving widow who would quietly sign the papers and disappear. What he didn't know was that before I retired, I spent 30 years at the FBI as a forensic handwriting analyst, and I have put men exactly like him in federal prison for exactly this kind of crime. He handed me the evidence himself, and then he told me to pack. Welcome back to Secret Confessions, True Stories. If you love stories where arrogant people fall headfirst into the traps they built themselves, hit that like button and subscribe to the channel. There are more stories like this one, and you do not want to miss them. Now let me tell you about the biggest mistake this lawyer ever made in his professional life, and why he made it the day he decided to underestimate a woman who had spent 3 decades reading the lies people leave behind in ink. Richard and I were married for 40 years. I want to start there with that number, because I think 40 years is the kind of thing that sounds abstract until you consider what it actually contains. It contains the apartment where we lived when we had nothing and were happy anyway. It contains the early mornings and the arguments that resolve themselves, and the particular silence of 2 people who know each other well enough to be quiet together, without it meaning anything except comfort. It contains the ranch. We built the ranch over the course of 20 years, which is to say, we built it over the course of most of our married life, choosing it and adding to it and improving it and caring for it, the way you care for something that is both a home and an expression of who you are together. The land was Richard's dream first. He had grown up with open space and needed it the way some people need proximity to water, a fundamental geographical requirement of his well-being. The house became mine as much as his over the years, filling with the particular accumulation of a shared life. The furniture chosen together, the kitchen where I learned to cook the things he loved, the porch where we sat in the evenings when the light did what light does on that kind of land at that hour, which is to say, it did something that made you feel, simply and completely, that you were exactly where you should be. I don't talk about my career much. This is a habit from 30 years of working in an environment where discretion is professional standard rather than personal preference. What I will tell you is that I joined the FBI in my late 20s with a background in document examination, and that over the following 3 decades, I became one of the Bureau's senior forensic handwriting analysts. The people called in when a signature on a contract or a will or a deed needs to be verified or challenged in federal court. I have testified as an expert witness in several hundred cases. I have a wall of certifications that I have never hung up because I have always found the hanging of certifications slightly performative. The knowledge is in the practice, not the paper. When Richard died, I was not prepared. I know that sounds strange. We were both in our late 60s, and at a certain point, the awareness of mortality becomes a steady background presence in a marriage, rather than a theoretical future concern. But knowing something intellectually and being prepared for it are not the same thing, and Richard's death was sudden enough that there was no transition, no gradual adjustment, just the ordinary morning and then the phone call, and then everything was different from that point forward. The days that followed are not something I will describe in detail, because they belong to me and to Richard and to our children, and because grief at that depth is not a narrative with a shape. It is more like weather, present everywhere, not moving through so much as you moving through it, very slowly, with no clear sense of direction. I will tell you that I was not functional in any meaningful way for a period of time, and that the people who loved me managed the practical things while I was not capable of managing them, and that this is, I have since learned, entirely normal. The meeting with the lawyer was scheduled for 3 weeks after Richard's death. His name was Preston Whitfield. A name that had always sounded to me like a character in a novel about people who went to the right schools and had never questioned whether they deserved what they had. He was in his mid-40s, dressed with the particular precision of someone who has concluded that visible expense signals competence, and he received me in an office that had been designed to communicate authority. Dark wood, leather chairs, the kind of deliberate weightiness that is meant to make the person sitting across the desk feel that they are in the presence of someone who manages large and serious things. He expressed condolences with the practiced warmth of someone who has expressed condolences many times and has developed a manner for it that bears no relationship to actual feeling. He offered tea. He arranged the documents on his desk with the careful organization of someone who has done this before and knows the sequence. And then he read me the will. It was, he explained, a revised document, dated approximately 1 month before Richard's death. Richard had, in this revision, made provisions to settle a significant outstanding debt to an entity called Apex Holdings, a business debt, Whitfield explained, that Richard had been too proud to mention, that had been hanging over the property for some time, that this revision was designed to address cleanly. The ranch, under the terms of this revision, would transfer to Apex Holdings in full settlement of this debt. There were other provisions, modest financial bequests, personal property, but the ranch, the house, the land that we had built and cared for over 20 years was gone. He leaned forward when he finished reading. He had a way of inclining across the desk that positioned him slightly above the person he was speaking to, a posture that communicated both intimacy and condescension simultaneously, which I suspect he had practiced without knowing he had practiced it. He said that the law was harsh, but that it was the law. He said he would help me find somewhere comfortable to go. He said he was very sorry for my loss. And then he said, "I can help you pack if you need assistance with that." I would like to tell you what I felt in that moment, because I think it is important to be accurate about it. There was grief, which was already the primary condition of every moment of those weeks. And there were other things underneath the grief. Disbelief, and then something that moved very quickly from disbelief into the cold, focused recognition of someone whose professional training had just been involuntarily engaged. Because I had looked at the signature. It is the thing I do automatically, have done automatically for 30 years, the occupational reflex that does not switch off simply because you have retired. I looked at Richard's signature on the last page of the document, and I read it the way I have always read signatures, not as a name, but as a set of physical gestures, a record of the movement of a specific hand under specific conditions, leaving specific evidence in ink on paper. The pen pressure was wrong. Richard had a heavy hand, not aggressive, simply characteristic, the result of decades of signing documents with a particular physical certainty that left a consistent depth of impression on whatever he wrote on. This signature was lighter, in a way that was not consistent with medication or age or physical change, but with the different hand of a different person attempting to reproduce what they believed his signature looked like. The loop of the R in Richard was wrong. It had a slight hesitation in it, a barely perceptible pause at the apex that leaves a microscopic pooling of ink, the physical evidence of a hand that is thinking about what it is doing rather than doing it from muscle memory. You cannot fake muscle memory. You can copy the shape, but you cannot copy the unconscious fluency of a gesture performed 10,000 times. The hesitation is always there for someone who knows where to look. The slant was wrong. Not dramatically wrong. Whoever had done this had been careful, had studied the signature, had produced something that would pass casual inspection, and probably legal inspection too, if the person inspecting it had not spent 30 years doing exactly this. But the slant had a slight rightward compensation that Richard's natural hand did not produce, a tendency of someone writing with deliberate control rather than natural movement. I looked at this signature for perhaps 4 seconds. In those 4 seconds, I knew with complete professional certainty that it was a forgery. I said nothing. I thanked Preston Whitfield for his time. I said I would need a few days to think about my situation. I said I was overwhelmed, which was true, though not in the way he understood it. I took the documents he had provided. I shook his hand. I left. I drove home, and I went to my kitchen, and I sat at the table that Richard had helped me choose in a furniture store 18 years ago, and I cried for a long time. Not only for Richard, though for Richard enormously, but also the rage, which is its own distinct feeling from grief, a heat beneath the cold of loss that has a different quality and a different direction. The rage of having been treated as a target, of having someone look at my grief and see an opportunity, of having Richard's name, the name in his hand that I had watched him write 1,000 times, reproduced by someone else for the purpose of stealing what we had built. And then I went to the basement. I have kept my professional equipment because I have never had a reason to get rid of it, and because some things, once acquired, become simply part of the furniture of your life. The magnifying loupes, the light board for transmitted and oblique illumination examination, the digital microscope with image capture capability, the reference materials. I set them up on the large work table in the corner of the basement where the light is controllable, and I began. I requested the original document from Whitfield's office. I said I wanted it for sentimental reasons, that having something with Richard's signature felt important to me, that I would return it promptly. He sent it without hesitation, which told me that he was confident in the forgery and confident in my inability to evaluate it. Both of those confidences were, as it would turn out, significantly misplaced. I spent 3 weeks in that basement with the document. I examined the ink chemistry under oblique illumination, looking for the particular fluorescence patterns that indicate different ink batches or pens, because even if a forger uses the same pen brand, the ink itself carries chemical signatures that can be compared. I examined the paper stock at the fiber level, looking for any evidence of erasure or alteration. I analyzed the stroke velocity, the width and pressure variation across individual letter forms that records the speed at which the pen moved, because genuine signatures made from muscle memory show different velocity patterns than carefully traced or slowly constructed forgeries. What I found was the complete technical picture of how the forgery had been executed. The signature had been produced by a process of guided tracing, a copy of Richard's genuine signature placed underneath the document, traced with deliberate control. The evidence for this was in the downstrokes, which showed a slight mechanical regularity that is the signature of someone following a pre-established line, rather than generating movement from motor memory. The hesitation marks I had noticed in the first examination were visible at magnification as ink pooling, the physical record of momentary stops. I also investigated Apex Holdings. This required a different kind of work, the kind that involves public business registrations, incorporation documents, and the patient following of ownership structures through the layers of anonymity that shell companies are designed to provide. It took time, but it was not complicated for someone who has spent years following paper trails of exactly this kind. Apex Holdings was incorporated in a state with permissive disclosure requirements. It had been established 14 months before Richard's death. Its ultimate beneficial owner, through 2 intermediate entities, was Preston Whitfield. He had forged my husband's signature on a will that transferred our home to a company he owned. He had then attempted to execute that transfer while sitting across a mahogany desk from me with an expression of practiced condolence. In the weeks while I was conducting my analysis, Whitfield had grown impatient. The eviction notices began arriving, formal, legal, each one more pointed than the last, each one implying that my continued presence on the property was becoming a matter that would require further action. He called twice, leaving messages in the tone of someone managing an administrative inconvenience. He had expected this to be resolved quickly, which is what people who do things like this always expect, because they have correctly assessed that most people in grief and shock will not have the resources or the knowledge to resist effectively. I filed a legal challenge to the will, not because I needed the court process to prove the forgery, I already had that, but because I needed Whitfield in a courtroom. I needed him standing before a judge, presenting his case with full confidence, committed to the document, with no escape route available when the ground shifted beneath him. The hearing was on a Thursday morning. I arrived early. I sat in the gallery and watched Whitfield enter, observed his manner in this environment. He was at ease in courtrooms in the way of someone who has spent years in them. He spoke to the bailiff with the easy familiarity of a regular, exchanged a brief pleasantry with the clerk, arranged his documents at the table with efficient, practiced movements. He was wearing a different, expensive suit, but the same fundamental confidence, and he glanced at me once as he settled in, a brief, accessory look that contained no concern. His presentation of the case was smooth. He had clearly prepared thoroughly, and he framed the situation with the particular narrative skill of someone experienced in making sympathetic cases for unsympathetic positions. He spoke of Richard's business obligations, of the long-standing nature of the debt to Apex Holdings, of the clear documentation of Richard's intention as expressed in the revised will. He was measured and authoritative, and he referred to me, in his framing, as a grieving widow understandably struggling to accept a difficult financial reality. Language that was technically sympathetic and functionally condescending, designed to establish me as someone whose emotional state made her an unreliable interpreter of facts. When it was my turn, I took the witness stand. Whitfield's cross-examination began with the particular technique of someone who intends to establish early that the witness is outside her competence. He used terminology deliberately, established the legal complexity of estate documents, asked questions structured to suggest that a layperson's assessment of document authenticity was inherently limited. He was not hostile. Hostility would have been too visible. He was patient, in the manner of someone managing a person who does not fully understand the situation they are in. I let him finish his framing, and then I asked the judge if I might establish my professional credentials for the record before responding to questions about my assessment of the document. Whitfield had not objected to this because he had no grounds to object, and because, I think, he had not yet understood what was coming. He was still operating in the version of this hearing he had planned. I listed my credentials: 30 years with the Federal Bureau of Investigation, specializing in question document examination and forensic handwriting analysis. Board certification from the American Board of Forensic Document Examiners held for 22 years. Expert witness qualification in federal courts across multiple districts. The number of cases in which I had provided expert testimony was, at my last count, over 300. I watched the color leave Preston Whitfield's face. It did not leave gradually. It left in a single moment, as though someone had made a technical adjustment to his circulation, and what replaced it was the specific pallor of someone who has just understood something that they cannot undo. I had brought my equipment. With the court's permission, which was granted, I set up the digital projector and connected it to my laptop, which contained the high-resolution image captures from my analysis. The image that appeared on the wall behind the witness stand was Richard's signature from the contested will, magnified 1,000 times, the individual ink deposits visible as geological formations, the physical record of every movement of the pen, preserved in full scientific detail. I walked the court through the analysis. I did this the way I would have done it in any federal proceeding, methodically, precisely, without editorializing, allowing the evidence to carry the weight rather than my presentation of it. I identified the hesitation marks and explained their significance: the ink pooling that occurs when a pen stops moving, the physical record of a hand that is thinking rather than acting from memory. I showed the velocity analysis, explained the pressure distribution patterns in the downstrokes, demonstrated how they differed from the velocity signatures of genuine handwriting. I showed comparison samples of Richard's authentic signature from documents whose provenance was not in question: the mortgage, the vehicle registration, the bank signature card, and walked through the specific, measurable differences between those signatures and the one on the contested will. I explained the tracing evidence, the mechanical regularity in the letter forms that is not present in genuine handwriting, the particular way that carefully controlled reproduction produces a different pattern of variation than motor memory. I showed it in the projection, pointed to it specifically, explained what it meant in terms that required no specialist knowledge to understand. And then I introduced the documentation on Apex Holdings, the incorporation records, the ownership structure, the beneficial ownership disclosure that led, through two intermediate entities, to a name the court already had before it. Whitfield had stopped taking notes. He was sitting with a stillness that was not composure, but its opposite, the stillness of someone who has run the calculations and found that there is nothing left to do. His complexion had moved from pallor into something that was closer to gray. He had a glass of water in front of him that he had not touched since I began speaking. The judge asked Whitfield if he wished to respond. He began to speak twice and stopped. What came out on the third attempt was not responsive to the evidence, but was a kind of procedural objection, a challenge to the admissibility of my expert testimony, which was several steps too late in the proceedings to be effective, and which the judge declined with a brevity that communicated clearly that she did not consider it a serious argument. The judge called a brief recess. During the recess, two things happened. The first was that Whitfield's attorney, he had managed to convey the need for one through some communication I did not observe, arrived and was seen speaking with him in the corridor in urgent, low tones. The second was that two federal agents, who had been contacted by the U.S. Attorney's Office in response to the documentation I had provided to them the week before, entered the courthouse. They arrested Preston Whitfield in the corridor outside the courtroom before the recess had ended. He was charged with felony forgery, fraud, and criminal attempt to deprive a property owner of real estate through falsified documentation. He did not resist. He stood in the corridor in his expensive suit while the handcuffs were applied with the specific quality of stillness of someone who has understood, completely and finally, how thoroughly they have miscalculated. The hearing concluded briefly after the recess, with the court vacating the contested will and reinstating the original, which left the ranch to me without encumbrance or qualification. The process of fully unwinding Whitfield's actions took some additional months of legal work, but the outcome was never in question after that Thursday morning. Whitfield was disbarred. The criminal case proceeded to trial and resulted in conviction on all charges. He received a federal prison sentence. The shell company was dissolved, its assets subject to forfeiture proceedings. I am sitting on the porch of the ranch as I tell you this. The light is doing what it does at this hour on this land, which is the same thing it has always done, and which Richard saw for the last time on a morning I cannot think about for too long without being overcome. The porch, the view, the particular quality of the evening here, these things are mine, and they are Richard's, and they will remain ours in the way that things remain shared even after one person is no longer there to share them. What I want to leave you with is this. A forgery is not a perfect crime. It cannot be, because ink on paper is not a neutral medium. It is a physical record of physical events, and physical events leave evidence, and evidence, by its nature, does not lie. The pressure of a pen records itself in the paper's surface. The velocity of a hand records itself in the variation of the ink deposit. The hesitation of a careful, deliberate movement records itself in the microscopic accumulation of ink at the points where genuine fluency was absent. Every lie leaves a mark. Every attempted deception leaves behind the physical evidence of the attempt. You need only know how to look for it and to have the patience and the training to find what is there, rather than what you expect to see. Preston Whitfield underestimated me because I was a widow and I was grieving and I was older than him, and he had looked at all of those things and seen someone who would accept what she was handed. He was not entirely wrong that I was all of those things. He was entirely wrong about what those things meant. The truth always leaves a mark. 30 years at the FBI taught me that. Richard's forged signature taught me it again, in a morning that began with the worst grief of my life and ended with the clearest professional engagement I have had since retirement. I found the mark. I followed it where it led, and I brought my projector. Thank you so much for spending this time with me today. If this story moved you, please leave a comment below. I read every one of them, and they mean more than you know. Subscribe if you haven't yet, and I will see you in the next confession.